Okay, well, welcome to Bianchi Law Talk. Sorry it's 5 o'clock today. I may be deciding to do these at 5 o'clock on every Sunday instead of 10:30. But as I put in the description, this has been an unbelievable week legally and politically with respect to the Kavanaugh hearings. And I am looking at this from the standpoint of law, not politics. And the question I pose here is, can both Brett Kavanaugh and Dr. Ford both be speaking a truth? There's nothing that's unusual about this that happens in a courtroom, and I'm going to get to that in a minute. But I want to tell you why I love the times we're in. Whether you're a D, whether you're an R, whether you're a Trump supporter or not, or whether you agree or disagree, I try to just keep it, like I said, to the law. And we've had some tremendous opportunities lately to really stretch ourselves in terms of our legal process and the importance of our legal process in a way we never were able to do it before. And what I mean by that is we've learned some things this week that I think are quite extraordinary, things that I didn't know. For example, when the Senate is doing hearings like we saw, the unbelievable hearings this week, there really is no standard format with respect to how you get to the truth. What I mean by that is we have all sorts of rules and procedures in the courts, evidence rules, manner in which witnesses are brought and interrogated in direct examination and cross-examination. There's a format. And, you know, I kind of used to look at it sometimes. I think it was kind of clunky and odd, but it hasn't been until the time I saw this Senate hearing that I realized the value of all the rules of evidence and all the rules of procedure that we have in the criminal courts and in the civil courts in each of our states in an attempt to try to, as best as we possible, lay an even playing field down so each side can fully and fairly get their information and data out there and let the jury or the judge or whoever's making the factual determination make a decision as to guilt or innocence, liability or not. And these hearings, boy, again, I get to the fact that the reason the public is so confused is that we're kind of mixing up and contorting legal principles being thrown out there by many of the legal experts with a political process, which is, with all due respect to the politician friends of mine, is not geared, in my opinion, in many instances, to gain the truth, but rather to score the political points they're looking for. So it's kind of got this look and wrapping that it's a hearing looking to get to the truth. But let's be honest, based on what we've seen, and each party is an equal opportunity offender in my mind. But we're going to talk about the Kavanaugh hearings and some of the things that we've noticed here. One of the first things that was shocking to me is there is no standard of proof in these proceedings. You've heard the term proof beyond a reasonable doubt. Well, that is a legal standard. We're going to get into that in a minute. That only applies to criminal law proceedings where the rules of evidence are so geared against prosecutors rather, as to make it very difficult to get a conviction before you deprive a person of their liberty. And these are rights that are enshrined in the Constitution for criminal defendants: presumption of innocence, Fifth Amendment right to remain silent, and the ability to cross-examine witnesses, and all those things only apply to the constitutional rights we have as citizens. They do not apply each and every day to civil cases. In civil cases, you can call the plaintiff or the defendant in a case. There's not a presumption of innocence. There is not a requirement for proof beyond a reasonable doubt. There's a different standard there. We'll get into that in a minute, like I said. The other thing that I find interesting is that there's no rules of evidence or engagement as to how witnesses are called or not called. It just simply seems to be, to me, whoever, again, Democrat or Republican, it's in the majority party, they can let you call witnesses, not call witnesses, limited how those witnesses are examined or not examined. Come on. This is not a way to get to the truth. This is, they may do it because there's political outrage about it, but they're only doing it for that reason. Their goal is to accomplish whatever political end they want. Otherwise, they'd have hearings more consistent with what we do in criminal court or civil court or administrative proceedings, all sorts of manner of things that we do when we are actually trying to prove a case in a real court of law designed to try to get to the truth. Now, there are a couple of misnomers that you hear out there, and again, confusion of legal terms in this political process, such as you can't convict on a statement alone. This is not accurate. There are many times as a prosecutor when you're dealing with the highest level of proof, that is proof beyond a reasonable doubt, where there is a presumption of innocence, and when you can't compel a defendant to testify, the hardest place to prove a case for a prosecutor, that you could put a witness on the witness stand in an old allegation, sexual assault, for example. I've done it as a prosecutor. I've got them as a defense attorney now, where you can put a witness on and the jury can evaluate the credibility of that witness without any corroborating evidence. Now, some states differ in this. Some states require at least some level of corroborating evidence, but it doesn't have to be dramatic at all. And virtually every case can have some level of corroborating evidence. For example, having said this to another person prior to the time that you're giving your testimony or the time you brought your complaint could be something that is corroborating. If you're looking for a great article about how the Senate is messing this up in terms of the mixing of legal standards in this political process, you got to see my friend Aaron Keller's article on this on the Law and Crime Network. There's a link in my video here where you can click on that. Aaron is a top-rate legal analyst and a host at the Law and Crime Network. I have great regard for him. In fact, I was there today with him hosting on that network on another case. So the other thing that I want to talk about is what they've said in the law for many years is the greatest tool that lawyers have and people have in order to prove the truth, and that is called cross-examination. It's called the greatest engine of truth that there is, to have both sides fully be able to have an opportunity to specifically ask cross-examination questions. Now, what's another oddity of what's going on in this case with respect to the allegations made against the judge? Well, typically speaking, in a regular proceeding, you're allowed to conduct discovery. You're allowed to have an investigation. And when you're armed with that investigation, you're able to then properly be able to examine and cross-examine witnesses. Of course, as you can expect in our political circus atmosphere that we have today, we're doing the complete opposite of that. And that, unfortunately, is a shame to both Ms. Ford, Dr. Ford, as well as Judge Kavanaugh. Because to me, either way, each one is entitled to a full and fair vetting through a full investigation. Now, I get it. My friends are going to say to me in some instances that it wasn't fair how this came out. It wasn't fair the manner in which it was released late. You may be correct, but we deal with that in the law as well all the time. And what a judge would tell you to do is give the an opportunity to be able to gather its own evidence in defense. In other words, you don't just disregard it. You may get spanked, if you will. You may get sanctioned by the court, but the court, in the process of trying to ascertain the truth, wants to make sure that everyone has all the evidence before them. Look, I've been involved in many complex criminal trials as a prosecutor where the standards for us and our rules are really strict. And sometimes something gets by you and it gets delivered late. The answer isn't most times that you can't use it. More likely the judge is going to give each person an opportunity to fairly present its evidence. Now, the standard of proof is something that I want to get back to in a minute. In other words, how do you weigh the credibility of witnesses and the facts? Well, again, it's shocking to me that the standard in the Senate is it's basically up to each individual senator as to what they feel the standard of proof is. What do I mean by standard of proof? Well, you heard me talk about proof beyond a reasonable doubt. That's the highest standard of proof that you can get in the law. And I just did some quick jotting down as to essentially what that means. That means the facts have to be proven to an honest and reasonable certainty of guilt from the evidence or a lack of the evidence. In other words, this is what the judge would say, ladies and gentlemen of the jury, you must be firmly convinced of guilt. But that only applies in most instances in criminal proceedings. So we see this conflation of using proof beyond the reasonable doubt in this Senate hearing, which is essentially a job application for a person who has no constitutional right to that. So proof beyond a reasonable doubt is a conflation of using a legal standard that does not exist in a hearing like this because there is no standard. But in civil cases, in everywhere around this country, the other standard of proof that we use is by a preponderance of the evidence. And a preponderance of the evidence, the jury would be told, simply means it's more likely than not. Another example, the jury be told, it's the scales just tipping ever so slightly like 51% believability, and then you can find that the plaintiff has proven its case if they prove it by 51%, that it was more likely than not. That's a much lower standard than proof beyond a reasonable doubt, to be sure. The other standard that's out there in some instances, and it's kind of arbitrary as to whether it's preponderance of the evidence or this standard, which is clear and convincing evidence. And clear and convincing evidence is kind of in between proof beyond a reasonable doubt and a preponderance of the evidence. And that means that you have to be substantially more likely that the person bringing the allegation is accurate or not. So listen, in the law, we know as lawyers when we go in there, whether we have to prove a case beyond a reasonable doubt by a preponderance of the evidence or clear and convincing evidence. Here, it's just willy-nilly. It's, again, left to the individual discretion and judgment and conscience of the political people that are there. Again, folks, don't disabuse yourself of the idea that these people are engaged in a political process. In my opinion, respectfully, not necessarily a search for the truth. If a search for the truth helps the political process, well, then you see one side do one thing as opposed to the other. But let's not, as a public, be confused about what is going on here. So I'm going to get to the ultimate point of, excuse me for my earpiece, what I was here to talk to you about. Is it possible that both could be telling the truth? Now, I say this for a reason. I've been around the block. I have watched independent witnesses view the same exact thing. In fact, I remember a case in which it was a shooting homicide, in which one witness who had no interest in the outcome of the litigation said it was guy A, and another witness who had absolutely no reason to want to lie or any motive said it was guy B. Well, what do you do as a prosecutor when you're dealing with this? Somebody shot him. It was one of these two people. This is not an unusual situation, and two people can see the same thing completely differently. Now, how do I mean that with respect to this particular hearing? I'm going to explain to you why. As I said to you earlier, a witness, especially in sexual assault cases, can come forward and say that they were sexually assaulted if they're within the statute of limitations in a criminal case. And remember, it's harder to prove a criminal case than it is a civil case, and certainly an employment application. And the judge would read to the jury at the end of the case, how are you supposed to weigh the credibility of a witness or multiple witnesses or even a singular witness? Well, they would say things, well, you need to judge their credibility with respect to evasion, their candor. Are the facts consistent? Do they make sense to you? Are there any inconsistencies? A big one. Who has a motive to lie? Who has an interest in disputing it or not disputing it? Is there corroboration? The ability to recollect? The specificity of the recollection? Alcohol or drugs that are used may go to the benefit or detriment of a witness. I've said consistency and inconsistency of testimony. In other words, many times in old sexual assault cases with child victims or young people, they are not able to give you a date, place, or a time. And that's why in the indictments we would put in the criminal context that it happened on diverse dates, separate dates between this period or that period. So this is something that goes on all the time in the criminal courtroom where it's much more difficult to prove the case. So listen, I really could care less one side or the other. When I give these legal opinions, it's kind of fascinating to me how people seem to only be responding out of a political response. And I get that. We are a divided, tribalistic country. But as a lawyer, it was very painful for me to watch that only two witnesses were allowed to testify here, that a person who was identified with being in the room was not brought into the hearing. Now, I know we have an extended investigation, but I ask you folks rhetorically, those of you who support the judge with respect to this issue, with respect to the sexual assault allegation, or those of you who support Dr. Ford, was it not enlightening? Was it not enlightening to actually listen to their testimony? Even the president, even people who were against Dr. Ford when they read her writing, who disputed her, attacked her credibility, when they saw her testify, the manner in which she testified, couldn't help but think that she was a very credible person. Maybe she's making a mistake. Maybe there's a confusion. Maybe she didn't present enough in order to overcome whatever burden of proof that these senators are being guided by, which again, I believe is politics and not the truth. Nevertheless, we need to hear from live witnesses with a full vetted investigation, with the opportunity for examination and cross-examination if the goal is to approximate the truth and get to the truth. I suspect that many in the Senate, and unfortunately many in the public, are more concerned about the politics and the optics of a thing than the truth of a thing. So I have never been more powerfully in favor of the rules of evidence in our courts and the rules of procedure and the standards of proof beyond the reasonable doubt, preponderance of the evidence, clear and convincing. I used to kind of think it was kind of like, oh, come on, we just kind of let the people just do it through the gut. But this proceeding is an opportunity for us to understand and exercise and massage why it is that lawyers and judges are valuable in most instances, if you will, even though everybody hates lawyers except their own. But it's a profession in which we are trying to get to the truth. Hey, guys, I'll be on MSNBC tomorrow at the 9 o'clock hour with Stephanie Rule. I'll be hosting at the Law and Crime Network again tomorrow from 12 to 3 on the Jessica Chambers case, which is a really, really horrible case. I know I have appearances on Fox News, CNN, and probably HLN during the week as well. Unfortunately, we'll probably be talking about the Kavanaugh thing over and over again. Hey, these are my brief thoughts. I'm not, again, saying it politically, but I do believe it's important that we understand the importance of the truth as opposed to the politics of a thing and dispel some of the misnomers and conflation between legal principles designed to get to the truth as opposed to political antics on both sides. So, give me your opinion. I know there's going to be a lot of sparked up conversation. And listen, I'd love if you guys could click on the link and look at Aaron Keller's article at the Law and Crime Network and always join us there. As well as I put a link there for Bianchi Law Talk on my YouTube video channel, and share this with your family and friends. I always appreciate your support. Bianchi Law Talk is going to be doing this from now on at 5 o'clock. I see that my friends Harris Kirsch are there and lots of folks that are on here, my wife and others. Unfortunately, my glasses are a little fogged up because it's hot in the room I'm in. But I will respond to each of your commentary, and thank you very much. Have a great weekend, guys. Let's not let the political circus, regardless of your political affiliation, get us so down and so deprecated that we can't at least look at this as an opportunity, good or bad, to make ourselves better. Because as a lawyer, man, I've been defining concepts and doing stuff and looking at law that I haven't looked at since I was in law school. That's how much my brain and all of our brains are being stretched with regard to the multiplicity of legal issues that are out there. I kind of look at that as a good thing. I hope you do too. Have a blessed week. Thank you.